No. May I please, your lordships? My lord, to mention item number 42. My lord, here affidavit is under preparation. So kindly allow me 2 weeks time, my lord.
Miss.
To your crew.
Habeas corpus or what?
Yes, my lord.
Then it should be from your reply should be prompt.
Yes, my lord, the
When?
affidavit is under preparation. I have received instruction, yes.
The minutes of the State Council. Federal Council affidavit. Of the state respondents is preparation and the thing will be filed within 2 weeks time. During the pyramid, command is the case. Filing of counter affidavit by the state.
Then, my lord, I beg to mention item number 44. Only 1 week time to file everything.
1 week. One. The VC. Only 1 week.
Lordship, on 30 August, the estate has extended the detention order, so I may be allowed to incorporate the.
City Land Council for a petitioner. And the state government has extended the period of he may be allowed to file edition readings to bring the order on it. Okay, allowed. Is the case after 1 week.
Much obliged.
May it please your lordship. Lordship, I'm appearing to VC, your lordship.
Yes.
Lordship, I beg to mention item number 50, your lordship. I appear for the appellant in this matter, your lordship. I have taken consent from the other side, your lordship. My pray the matter may be taken on of 6th, your lordship, 6th of November, your lordship.
6th of November.
Lordship. It's a Wednesday, your lordship.
Lordship.
Mr.
N. Gautam, your lordship.
N.
N. Gautam, your lordship.
M.
N. Gautam, your lordship. Navneet Gautam, your lordship.
Oh, yes, yes.
Lordship.
N. Gautam. Senate Council appearing for the appellant. Submitted that as the meaning of difficulty to address it today. Case listed of November 2020. It's submitted from Mr.
And
N. Mojui, Senate Council for the respondent number
2
2 and 3.
Lordship.
Anybody else?
Private respondent 4 to 11.
Your name is Menosiano. Yes, Menosiano, Senate Council for the respondent number 4 to 11 are present. As Mr. As the prayer for the case on 6th November 2008 with the consent of the other sides, release the case accordingly also.
Lordship. Bless you, Lordship.
Lordship. Obliged.
Legacy Lordships. Lordships, I beg to mention item number 43, my lords. Lordship, here we have received the affidavit filed by the state yesterday, my lord. So if this matter can come up after the puja break, my lord, that is on the 16th for admission hearing, my lord.
16.
Yes, my lord.
Okay. As sought for by MS Lucino,
Yes.
Senate Council for a petition and Mr. Tipa
Yes, my lord.
from the State Council is the case on 16.
Obliged, my lord.
Much obliged.
10.
May I please, your lordships? Lordship, I beg to mention item number 5 on behalf of A. Ahmed. Kindly list this matter on 11th December.
You are for a petitioner,
I'm for the respondent, your lordships.
respondent. Okay. CGC,
Yes.
Mr. Yangarbuti, Learned Central Government Council for the petitioner, and Ms. Chivek Rulu,
Yes, your lords.
Learned Council for the respondent, sole respondent,
Yes, your lords.
petitioners and sole respondent are present. As sought for by the Learned Council for the parties, leaves the case on 11.
11th December.
12.
Lordship, let it be on November 6th. Most probably I'll be withdrawing this case.
Okay.
November
You
6th,
withdraw
what is-
better,
I'll be withdrawing, the union will be withdrawing the.
so it will be for your benefit.
Yes, your lords.
The early the better. Okay, 6th 11. 6th 11.
Lordship, I also beg to mention item number 41. Lordship, this matter come up after 4 weeks, Lordship. I have not received any instructions as of now.
Have not received instructions.
My lord.
2022 matter,
Yes, my lord.
who is put up?
I'm for the
Petitioner.
petitioner.
MS so-and-so learned counsel for the petitioners is present. Mr. Yangarvati learned on the
Yes.
prayer of Mr. Yangarvati learned Central Government Council for the respondent. Okay, release the case. The matter will list it after 4 weeks.
Yes, my lord.
MS Sukri, you were there.
Yes, yes, I'm for the
Okay.
state.
And Miss Sukri, P. Sukri, learned additional advocate general for the state of Nagaland are present and on the prayer of.
Lordship.
May I please, your lordship? I beg to mention item number 6 to 39.
39.
Yes, your lordship. I'm appearing on behalf of my senior Nityo Koza, counsel for the petitioners. Kindly grant us 2 more weeks as we are yet to receive instructions.
Further matters?
Lordship, it pertains to the non-availability, the allegation of manpower infrastructure in the health sector, Lordship. We have filed a detailed affidavit, and the court has taken a conclusion saying that like the prayer sought in the PIL is almost answered with Lordship. However, the petitioner was given the liberty to ascertain from the respective health units whether they are satisfied with the facility that we have provided.
Okay. They give the file, item number 6.
This is a case of.
Union is also a party.
Well, yes.
Your MS Loreno,
Abi,
Abi, land counsel for the petitioner. Petitioners. Miss Diane Mojui. Standing counsel.
Standing counsel.
Standing counsel,
For respondent number.
health and family welfare or what?
No, National Health Mission.
National Health Mission.
Yes.
Mr. Imti Imchung, learned additionally for the state of Nagaland and Mr. Yangarvati learned Central Government Council. Not present. Full stop. Mr. Mojui has submitted that as regards the grievances made in this petition regarding, in this PILs regarding inadequate nature of facilities in the health sector, comma, a comprehensive affidavit
Lordship.
has been filed, has already been filed
Yes.
on behalf of the respondent National Health Mission,
Lordship.
bringing on record the facilities presently available
Lordship.
in different health facilities across the state. MS so-and-so learned counsel for the petitioner, PL petitioners, has submitted that cases be listed after 2 weeks in order to obtain further instructions. As regards the contentions made by the respondent authorities in their affidavits in opposition, counter affidavits. List the case. Surprise allowed, list the case accordingly after 2 weeks.
Obliged, Lordship.
Cases.
Obliged.
your lordship, item number 40 as well. Item number 40.
40.
Yes, The additional affidavit is under preparation. Kindly grant us 1 more week.
This is not part of this batch. Okay, MS so and so. You are there?
Yes, sir.
Yes,
Good.
yes, I'm for stay.
MS so and so, learned counsel for the petitioner. Mr. Ingravati, learned central government counsel for the respond number 1. C. Shukri, learned additional advocate general for the Nagaland for the respond number 2 to 6 are present. On the prayer of Miss so and so, learned counsel for the petitioner, release the case after 2 weeks. 2 weeks.
For motion. Item number 1.
Yes, Lordship. Lordship, the I is for condonation of delay, Lordship. There's a delay of 66 days in preferring the appeal, Lordship.
Who are the respondents?
Respondent, state respondents, Lordship.
Lordship, I'm for the response.
Yes.
For the delay, Lordship, I have no objection, Your Lordship. Yes.
You can condone.
Lordship,
Only state respondents are
Yes,
there.
yes,
Your Lordship.
Yes. Heard, Mr. Mujui. Learned counsel for the applicants. And MSP Supri. Learned additional advocate general. For all the opposite parties.
Lordship.
The instant interlocutory application under section 5 of the Limitation Act 1963 is preferred seeking condonation, the rate which rules so and so, chapter so and so, Gauhati High Court rules. Close that. Is preferred seeking condonation of delay of 66 days
Lordship.
in preferring the accompanying writ appeal. Full stop. The accompanying writ appeal has been preferred to assail the judgment and order dated
10/6/2024
10/6/2024
in the
passed by
BBC.
the learned in a writ petition from a WPC number 279/2022 passed by a learned single judge.
Lordship.
Full stop. By the judgment and order dated 10/4/2024, the repetition, WPC number 279/2022 preferred by the applicants as writ petitioners. Has been dismissed.
Lordship.
Full stop. We have gone through the statements and amendments made in the instant interlocutory application. More particularly, paragraph
10, Lordship.
10 thereof. Having gone through the same, we are of the considered view that the applicants been able to show have been able to explain the reason for delay, showing sufficient cause. Full stop. MSB Supri, learned additional advocate general. Nagaland appearing for the opposite parties have submitted that state CS no instruction from the state to oppose the instant application for condonation of delay, and has really submitted that the accompanying writ appeal can be hard on merits.
Lordship.
Full stop. In view of the above, the instant interlocutory application seeking condonation of delay of 66 days in preparing the accompanying writ appeal stands allowed. Full stop. The registry to register the accompanying appeal and thereafter list the same for admission.
Lordship. Oblige, Your Lordship. Lordship, in item number 2, delay of 54 days, Lordship.
54 days, minute.
Item number 2.
Item number 2. 54 days.
Yes.
Yes,
Other things are
The
same.
Lordship, same.
Judgment and order same.
no, different.
Different Lordship.
Writ petition also.
Writ
different.
petition is 278
278.
of
And
2022.
22.
Yes.
And
The
judgment
order
and
is dated, same dated.
Okay.
Same dated. Order is same dated.
Much good.
Oblige, Your Lordship.
For admission, item number 3.
Yes.
May I please, Your Lordships? Your Lordships, I'm appearing on behalf of my senior, Joshua Shekir. My senior couldn't appear today due to some medical.
Senior?
For respondent number 9, Joshua Shekir. He couldn't,
Is for which
for the
which
contractor,
authority?
for the contractor.
Contractor.
Yes, he couldn't appear today due to some medical emergency at home. However, we have filed a affidavit in compliance to this honorable court's order dated 049/2024.
04
9/2024. Yes, Your
09
Lordships.
2024.
May I, my lords?
Yes, yes.
My lord, by the order dated 4/9/2024, the parties, the official respondents on one side and the contractor on the other side, were given 3 weeks' time to try and resolve their differences. However, affidavits have been filed, which we have received, your lordships, and the differences are not yet resolved. And it would appear that each side is blaming the other for not fulfilling their obligations. And the contractor, on its part, has already served a notice to terminate, and it appears that the contractor has already acted on it, my lords.
Contractor has served a notice or
Notice
contractor
to terminate the contract.
who has served a notice? NHIDCL
The contractor has served to the NHIDCL.
or contractor has served?
Lordship.
Yes, my lords.
Okay. Seeking what? Termination.
Yes, termination of the contract.
Okay.
So what do the official respondents propose to do, your lordship? That is the question now.
Yes, who is for the NHIDCL?
Lordship, I'm representing-
Yes.
We have filed 2 affidavits, Lordship, one yesterday and on 18 September 2024. Lordship. We have also included the meeting minutes, Lordship, as well as the letter status of as of today, Lordship. Lordship, as per the meeting minutes, Lordship, the contractor was also summoned. The representative of the contractor also was in the meeting, Lordship. They have expressed that they may not be able to continue with the work, Lordship. Lordship, I also kindly appreciate that on 4/9/2024, the last order, Lordship. This honorable court has also observed about the NIT which we have floated, Lordship. And this such time the NIT state by this honorable court, Lordship, not to go ahead with the NIT, Lordship. Now, as per the intention expressed by the contractor, they are not in a position to go ahead with the.
What is the affidavit? What the affidavit states? Of the contractor?
The contractor says that, your lordship, the contractor says that he is not in a position to complete the contract anymore.
So there will be impasse.
Yes, my lords. We are now at an impasse.
If I may, your lordships, the
Contractor activity. Contractors. Oh,
no,
the
we have filed yesterday.
affidavit of the contractor is not on record.
Next was filed yesterday. Yesterday.
Mr. Ma, you were also saying that you have filed a affidavit.
Lordship,
When?
on 18 as well as yesterday, Lordship.
Yes.
Lordship. Ultimately, I really appreciate that the authority engineer, they have also filed the affidavit stating that the contractor has abandoned and demobilized the materials, Lordship.
Your affidavit is by Tapas Kumar Pathi.
That is
It's
the contractor,
contractor.
Okay, it is there. It is filed on 24 second today. Oh, and the other one?
Respondent number
Your
288,
was
Lordship.
filed by?
288, Lordship. Respondent number 288.
Lordship,
NHID, sir, Lord.
I have also filed an affidavit this morning, Lordship, stating that there is zero,
Who is respondent number 9?
the contractor,
Contractor, Lordship.
and respondent number, yes, respondent number 10, Lordship, is the authority engineer, on whose behalf I have filed an affidavit this morning.
You are for
I am for the respondent number 10, the authority engineer, Lordship.
authority engineer.
Yes, I am supervising the work that is being executed by the contractor, Lordship. I have filed an affidavit this morning stating that the contractor has not been making any progress in the work since August, and that, Lordship, he has already started demobilizing his manpower and machineries.
Yes, Mr.
The work site.
Dimoni, you have received this copy.
Yes, my lords, I have received it.
Respondent number,
Respondent number 9 and 1, 2, and 8.
respondent number 10.
Respondent 10 also I have received, my lord. Yes.
10 received. 9, okay. And NHIDCL, when?
18, 9, 2024 and 24, 9, 2024. Lord.
Latest one.
24. Yesterday, Lord. Respondent number 288, Lord.
2 and 8.
Yes, Lord.
Your affidavit is dated?
Dated 24, 9,
It is
2024.
there.
I've enclosed even the photographs, Lord.
Yeah, my lords.
Yes.
My lords, by the order dated 09/24, the NIT which was floated by the respondents 2 and 8 was suspended during dependency of the attempt to resolve the differences between the parties.
Yes.
Now, by this affidavit dated 24/9/2024, the NHIDCL wants to go ahead with the tender process. That is what they are asking for, my lords. Until such time that the tender process is complete, they say that this honorable court should direct the contractor to keep maintaining the road.
If I may, Your Lordships,
Ah.
Your Lordships, on 7 September,
Mr. Seki represents whom?
the contractor,
Yeah.
respondent number 9. Actually, on 7 September, they have held a meeting and they have
Okay, Mr. Seki will be available on Friday,
on
this Friday.
For tomorrow.
Lordship, I cannot say that because there's a medical emergency at home and
Because we may have to vacate the order.
and on Monday,
Okay, Mr. Monday,
Monday is fine, my lord.
Monday, we go through this affidavit. We may permit planning side is to go ahead with the tender process. Because otherwise, it will be as per the terms and conditions.
Yes, Lordship. It is part of the contract agreement also.
Definitely there will be the risk and cost
Yes, Lord.
clause.
Yes.
Yes, Lordship.
Risk and cost clause must be there in the.
10.4, Lordship.
We are not going into that aspect. Okay, write down the name, Mr. A. Jimomi. Learned amicus. What is it? What is it? Learned amicus. $9,024. So many things. 49,024. What is that? A. Jimomi. Planet amicus curie. Mr. Moaz Amir. Planet counsel for the NHI DCL. Stroke respondent number 1, 2, and 8.
Lordship.
Mr. Imti Imchong. Planet additional advocate general for the Nagaland. For the respondent number 2, 3, 5, 6, 7, 11, and 12. And Mr. Sentia Anger, Planet counsel for the respondent number
10, Lordship.
Mr. Zamir has submitted an affidavit on behalf of the respondent NHI DCL has been filed in deference to the order dated 4/9/2024. Mr. Santianger, Granted Counsel for the respondent number 10, has also submitted an affidavit.
Yes, Lordship.
In deference to the order dated 4/9/2024 has already been filed on behalf of the respondent number 10. MS.
Honbini Izum.
Learned Counsel representing Mr. Joshua Seki, Learned Counsel for the respondent number 9 stroke contractor, has submitted that due to medical emergency, Mr. Seki is not in a position to attend the court today and has prayed for listing of the case on Monday for further consideration. MS so has submitted that the respondent number 9 stroke contractor has also filed an affidavit in deference to the order dated 4/9/2024. So stop. Having regard to the prayer made on behalf of the respondent number 9, list the case on Monday. Monday will pass out.
Much obliged, man.
Mr. Yomi, you have no problem? Monday?
Yes, madam, no problems. I'll be there on Monday, my lords.
For admission, item number 4.
May I please, Lordship. My lord, the present petitioners are graduate teachers in education department, numbering 50 of them. And in the present case, the petitioners are challenging the rules, particularly Rule 15 of the rules, by which the department first sought to bring parity among unequals with equals. Secondly, that too by bringing into the fold of selection of NPSC, which is not German, to the entire system of recruitment in the education department, my lord. My lord, may I just go to the read? Allow me to read the read petition. Page 13, my lord. Page 13, paragraph 2. May I read it, my lord? Paragraph 2. That the petitioners are aggrieved by certain provisions of the Nagaland School Education Service Rules 2017, hereinafter referred to as Rule 17 rules, application of which have resulted in total disparity in the matter of promotion to the graduate teachers vis-a-vis the primary teachers. Although representations have been made agitating the grievance in this regard, but the same has remained unattended to. Further, although a committee has been constituted to examine and review the said 2017 rules, but the same has also remained static without any progress whatsoever. On the other hand, the Nagaland Public Service Commission, NPSC for short, has issued the impugned advertisement dated 21/7/22 as per the requisition placed by the state government in the Department of School Education for filling up of the post of assistant headmaster / junior education official. If the said process is allowed to be completed, the grievance of petitioners will remain unattended to. Hence, this read petition. Paragraph 3, page 14. That the petitioners are all graduate teachers working in different schools throughout the state of Nagaland. They are governed by the aforesaid rules of 2017. Because of the apparent disparity in certain provisions of the said rules, they are now sought to be deprived of a fair consideration in the matter of promotion to the post of assistant headmaster / junior education officer. 4. That Rule 3 of the 2017 rules under the head code, Constitution of Service unquote, provides that the service shall consist of persons who at the commencement of the rules were holding regular appointment to the post specified in Schedule 1, and also the persons recruited to the service after the commencement of the rules. Rule 4 makes provision for gradation and strength of service. Rule 5, providing for method of recruitment to the post specified in Schedule 1, makes provision for direct recruitment or direct from lower grade or by promotion or by selection through limited departmental examination. In the present proceeding, the issue involved is limited departmental examination and the criteria and procedure thereof. 5. That Rule 6, Clause B, makes provision for direct recruitment to the post of graduate teachers, primary teachers, graduate Hindi teachers, primary Hindi teachers, graduate physical education teachers, primary physical education teachers, graduate language teachers, and primary language teachers. Rule 6B, sub-rule 1, clause 1, provides for a departmental selection board consisting of the following. Page 15, my lord. Serial number, head of the department chairman. 2, representative department of PNR not below the rank of undersecretary member. 3, representative of secretary in charge of Department of School Education not below the rank of undersecretary member. 4, an official to be nominated from the Directorate of School Education to be nominated by the department member secretary. Paragraph 6. That Rule 6B, clause 8 and 9 respectively lays down the weightage for academic records for all categories of graduate teachers and all categories of primary teachers as follows. These are the weightage to be considered. Graduate teachers, examination weightage. For graduate teachers, SLC exam, 10% of the aggregate marks. B, 10 plus 2 examination, 15% of the aggregate marks. C, degree level examination, 30%, 35% of the aggregate marks. D, DID, PhD, certificate, diploma in physical education, 35% of the aggregate marks. E, honors or higher qualification like PG, MPhil, PhD, 5% marks. Now down below is for primary teachers. What is the weightage to be given? HLC examination, 25% of the aggregate marks. 10 plus 2 examination, 35% of the aggregate marks. DLED slash PSTE certificate slash diploma in physical education, 35% of the aggregate marks. D, for higher education qualification, 5% marks. So these are the weightage to be considered for the promotion. My lord, then paragraph 7, page 17. That Rule 7B, sub clause 2 of the 17 rules lays down the qualification for direct recruitment inter alia to the post of graduate teacher and primary teacher. For a ready reference, education qualification for graduate teacher and primary teacher as laid down in Rule 7B subclause 2 and 7B subclause 3 are indicated below. This is for 1, 2. That require educational qualification for direct recruitment to the post of graduate teacher in various subjects shall be as follows. A, graduate oblique postgraduate with at least 50% marks or an equivalent degree. Relaxable by fair person for scheduled tribe slash scheduled caste slash differently able candidates in either graduation or post-graduation at the bachelor's degree level in the relevant subject from a recognized university. B, Bachelor of Education, B.Ed, BA, B.Ed, BSc, B.Ed, BSc, BSc Education from any National Council of Teacher Education recognized institution. And C, besides fulfilling the above qualification, the candidate must have cleared the state teacher eligibility test conducted by the SCERT. Now down below is for primary teachers. What is the education qualification? The required education qualification for recruitment to the post of primary teacher. A, senior secondary means class 12 or its equivalent, or graduate with at least 50% marks or equivalent grade relaxable by 5% of scheduled tribes. For scheduled tribes, scheduled caste, differently able candidates from a recognized board or university. B, PSTE or DIED or Bachelor of Education, BA, ED Education, BSc Education from any National Council of Teacher Education from recognized institution. And C, besides fulfilling the above qualification, the candidate must have cleared the state teacher eligibility test conducted by SCERT. So the basic difference between the basic difference of education qualification between primary and graduate is for graduate minimum is graduate, but for
In your case,
yes,
there is a set of rules.
yes,
General teacher is in a different category with different qualification, with different scale of pay. Primary teacher with different set of essential qualification.
Yes.
With different scale of pay and different grade.
my lord. That is
the
it.
service.
Yes, as per rules.
There, say, graduate teacher is
Yes.
on a higher pedestal, primary teacher is on a lower pedestal,
My lord.
according to it.
Exactly.
So as per the normal promotion
Yes.
and revenues,
Yes.
one primary teacher cannot become a graduate teacher.
Directly no. As per the
It
rules.
appears from rule 14.
Yes. Directly cannot.
That a
For-
primary teacher will be eligible for senior grade primary teacher.
Yes, my, I'll come back to the rules, my lord.
Just
Yes, yes. Exactly.
understood, just to
Lordship,
understand.
exactly, Lordship has pointed out.
So he cannot become graduate.
Never,
even
never.
if he has the graduate qualification.
Very much. Even though he has postgraduate, graduate.
And a graduate teacher can become senior
Graduate teacher?
teacher on completion of
Yeah.
minimum qualification of
Yes.
service.
Yes.
So they are on a different pedestal.
Yes. Yes, ma'am. Exactly, ma'am.
Yes. It is not that for assistant headmaster or junior education officer,
Yes.
by normal channel of profession, they have been made.
Yes.
Here is a case of limited departmental
Yes.
examination.
Yes.
Right.
Correct.
Eligibility to appear
Yes.
in the limited departmental examination,
Yes.
at that level, both of them have been put on equal pedestal.
Yes.
But they will be selected on the basis of marks only. There will be element of competitiveness.
Yes.
And to enter into that competition, they have been made at par.
Correct.
Here is a question, here is not normal promotional avenue,
No, no,
not this way.
no.
They will jump.
Two
They will
stages.
jump.
2 stages they will jump.
Right. So to enter into that competition,
Yes.
both of them
Yes.
are made at par.
Yes.
Now that is what? Because the element of competitiveness is the criteria to be an assistant headmaster or junior education officer. Now it is in that context, Article 14 is to be
Yes.
examined.
Yes.
Because element of competitiveness
Correct.
is there.
Yes. To reach.
Suppose for a Nagaland Public Service Commission, Nagaland Civil Service, a doctor, a simple graduate, an engineer, an IIT graduate, a veterinary doctor, an agriculture graduate, all are eligible, provided they have a degree. Right?
If the entry point is same.
No,
Here is the case of promotion.
here is a promotion. So what
Not
is
in,
the-
not direct entry.
because there is an element of competitiveness.
Yes.
Competition, not normal promotion. Had it been by normal promotion, yes, purely ex officio. Now here is an element of competitiveness. There is a competition, there are 3 papers, and basically on professional education, fundamental rules, service rules, office procedure, general knowledge, general English. Because assistant headmaster perhaps is an administrative post. Is it correct or
Correct.
wrong? Junior education officer, they are administrative post.
Yes, Lordship.
Perhaps assistant headmaster is an administrative post or non-administrative?
Mm.
Please tell me. In Assam, it is basically administrative. They do not teach.
Mm.
They do not go to the classes. Headmaster also. Suppose few teachers are absent, then only headmaster goes to the class. Just to, so that student does not make noise. But this assistant headmaster or junior education officer, are they administrative posts or teaching posts? Am I clear?
Correct.
That is the core issue.
Yes. I'll come.
I think assistant headmaster, responsibility of assistant headmaster is teaching coupled with administration
Yes.
of the school.
Correct.
Let us
Assist
see.
the high.
Service
Assist the
rules,
headmaster.
anything is there? Let us
My
see.
lord.
Assistant headmaster, is it there in the service rules?
Yes, my lord.
Where is
Lordship,
that
I'll come to
assistant
that.
headmaster?
Where is it?
Assistant headmaster.
Lordship, schedule 2, page 28, schedule 2,
page 28 of.
29.
Of your petition.
No,
No,
service.
rules.
Why challenging? You have not.
Yes, they have
Well,
not annexed the service rules.
They have not annexed.
Yes.
Well, I have taken that plea.
You are challenging.
I have taken that plea, my lord, in the, that's why, once I read Schedule 2, page 28, continued at page 29, headmaster, assistant headmaster.
What is this senior legal assistant?
My lord, these are new post grade.
Huh?
To give legal advice, to offer legal advice to department. Some of the junior advocates have been appointed as legal consultant.
Yes, I mean, we should create.
In
Senior
the-
legal assistant will be assistant headmaster.
Lordship, they are in the grade of graduate teacher. They are holding the equivalent post of graduate teacher, Lordship.
No, how then if.
Because
my
of the,
Brothers, viewpoint is correct, that assistant headmaster also takes classes. Then this senior legal assistant, who has been made at par with senior graduate teacher, senior graduate teacher becomes senior graduate teacher only after 7 years of graduate teacher. How can this man can start taking classes?
page, senior legal assistant, where is the? It's an administrative.
Page
Your
I
Lordship.
could understand that senior
Page
legal
30.
assistant
Page
will
30.
only become junior
30.
education officer.
Page.
That's for the equivalent post, Your Lordship.
I could
Equivalent
understand
post.
that senior legal assistant becomes only junior education officer.
Mhm.
But if he becomes an assistant headmaster, it will be chaos.
No, Your Lordship, see, because they are appointed in the rank of a graduate teacher, only a graduate teacher, they, with Lordship, see, the post of senior legal shall be filled up on posting from amongst the graduate teacher / legal assistants with LLB who have completed 7 years as graduate teachers.
Which
In the third, 1, 2,
Page?
3, page 30,
30.
yes, page 30, serial number 10 in the last column. Last column, Yes.
Amongst graduate teachers.
so here,
In
Lordship,
in education, but why you need legal assistant?
no, Your
I
Lordship,
don't know.
no, Lordship, we have so many litigations for that matter, Your Lordship,
No,
yes.
But ma'am, will it not have been proper if the post of a senior legal assistant was differently channelized,
Yes.
Mm.
not mixing up with
No.
the teaching faculties?
Lordship, this is a position, but in the LDE, Lordship, they can also participate because they are holding equivalent post of a graduate teacher, Your Lordship. Because LDA talks about graduate teacher, primary teacher, and others holding equivalent posts. And the only limited grievances before this honorable court is with regard to LDE only.
Anyhow, for the present case, we are not concerned with this senior legal
yes.
assistant.
No, no.
No.
Because
Now,
as,
now, then come to page 29. Entry number 7.
Yes, assistant headmaster,
Yes.
junior education officer.
Now,
Your Lordship.
normally we, I don't know, subject to Mr. Joe
Mm.
submitting it.
Lordship.
Normal promotion channel say after 7 years, at least 7 years. of service.
Lordship.
The feeder cadre is
Mm.
for assistant headmaster and junior education officer.
Senior
is
graduate teacher.
Senior graduate teacher
Yes.
and legal assistant.
Yes, senior
Right.
legal assistant. Yeah.
And by way of limited departmental examination, that was my basic idea till date.
Yes.
That for faster,
Accelerated promotion.
accelerated
Yes,
promotion,
yes,
limited departmental examination so that meritorious candidate can
yes, participate in that.
participate and
Yes.
succeed. No,
Yes.
meritorious candidate, all can participate.
Yes.
7 years or 5 years or whatever.
Mm.
Because sometimes even after 12 years,
Yes,
person may not get promoted.
true that.
Right?
Exactly, Lordship.
Limited departmental examination is conducted or held
Mm,
for the purpose of selecting
mm,
the meritorious candidates
mm,
out of the pool or zone of consideration
yes,
in the feeder cadre.
exactly,
Right.
Lordship.
That
Yes,
is my concept till then.
yes, and only
Until
those.
seeing this rule. But here you have expanded the zone of consideration
Mm,
for limited departmental examination
mm.
by including these primary teachers and equivalent grade. That is the cause of grievance for a petition.
Yes, but your Lordship,
If
here,
I have understood
Yes.
correctly.
And that also provided they have degree certificate.
Lordship,
that is
yes,
okay.
Lordship, the intention of the lawmaking authority is that we don't give importance to the grade or the entry level. We give only importance to the educational qualification. That
No.
one should have graduate or postgraduate. The
Can
other
you-
one is
Can
Lordship.
any of you can apprise about what is the purpose and intent of limited departmental examination?
Yes, Lordship.
What is the purpose and intent?
Lordship, so
The
that
basic idea.
yes, the basic
The
idea is
idea I have also in my
Yes.
mind, but what is the settled position?
yes, Lordships here. See, if there is not limited departmental examination, the petitioners and the other also will have to wait for the promotion. It may not even reach during the lifetime. So in order to have the accelerated promotion through merits, your Lordship, 20% of the post is only reserved. Yes, yes,
I can understand.
yes, Lordship.
The question is
Mm.
that this is the position.
Mm,
Now, not, I understand, say this way, see this way.
mm,
This is the promotion.
mm,
The zone of consideration will be for normal promotion is senior legal assistant
Mm.
and senior graduate teacher.
mm.
For assistant headmaster and JU.
Yes, Lordship.
That is normal promotion channel.
Yes.
But here, for limited
Mm.
departmental examination, you have expanded the zone of consideration.
Mm.
You have included everybody,
Yes,
primary teacher
yes,
and
graduate
equivalent
teacher.
grade.
Yes.
Hindi teachers,
Equivalent grade.
Yes, equivalent grade. Yes.
physical.
So you have expanded the zone by
Mm.
10 times.
Mm,
Now, I want to know,
mm,
because my idea,
mm,
not from any, I have derived this idea,
Mm.
not from any settled position.
okay. Mm,
That it is an accelerated kind of promotion from the
Mm.
feeder cadre.
yes.
That was my idea.
Mm, mm,
Now, as per this service rule,
mm,
the feeder cadre was not made limited to
mm,
the senior legal assistant and senior graduate teacher.
mm,
You have expanded the concept of feeder cadre to include all.
mm, mm.
Now, my question is, what
Mm.
is the settled position as regards limited departmental examination?
Okay.
Purpose of intent and object.
Lordship,
Uh,
to have the efficiency in administration,
That I
Lordship, yes.
But question is that broadening the zone of consideration.
That means they have to compete in the
Yes, element of
examination.
competition is
Yes,
there.
Lordship.
But my question is at the bottom,
Mm.
feeder cadre. Whether
Mm.
feeder cadre can be expanded in such a way.
Yes, because provided that they have the qualification, because we have given
Do you
the,
have any
we have
authority
given
on
the-
departmental question?
Lordship, we have given the,
Lordship make point.
that
with
they
due
should,
respect.
they should have the either postgraduate or graduate
I
degree.
have understood the
Then they should
idea.
have, yes.
I have understood the idea. I
Lordship,
have
yes.
already expressed.
Lordship,
I have understood the idea behind it.
yes,
The
Lordship.
question is whether this is permissible or not.
Yes,
That
it's-
is what.
Yes, it's permissible. In order to have the
Permissible.
accelerated, your Lordship, and the petitioner,
Accelerated, quite all right.
okay.
It is quite all right,
Mm.
accelerated.
Mm.
But while doing that, whether you can expand the zone of consideration.
Lordship, yes.
That is what I am asking.
Yes.
Idea is all right. 20% reservation for through limited departmental examination, all right. All right.
So, Lordship.
Because normally stagnancy is there, normal
Yes.
promotion avenue.
True, Lordship.
Meritorious candidates should be preferred by limited departmental examination. So they can participate, they can show their ability, merit by appearing in the examination. It is quite all right. But this, normally I had the idea that limited departmental examination is also from the feeder cadre. In the promotion, normal promotion, the feeder cadre is clearly defined. Confirmed senior graduate teacher and confirmed senior legal assistant. But at the time of limited departmental examination, you have expanded the feeder cadre, concept of feeder cadre. Whether that is permissible.
So, Lordship,
Because otherwise, primary teacher has a normal
Channel promotion.
channel of
Yes.
promotion.
Lordship,
Why you have not bracketed limited departmental examination in that particular? Let us see primary teacher.
Page 42 of the service rule, Your Lordship. 42.
Primary teacher.
Yes.
Yes, heading,
Page
column, page
42,
column,
serial number 5.
column 10. Yeah.
Serial number 5, primary teacher.
Column 10, heading, primary teachers. The entry point is primary teacher.
And what is this area education officer?
Yes. Now the
Primary teacher.
this is the
Then
channel
senior primary teacher.
Yes, grade 2.
Grade
two.
1.
Then
thereafter
grade 1.
to grade 1.
Area education.
Area education officer.
Then senior area.
Now you have brought this, all this.
Yes.
Vocational education also, all
Yes.
these into that.
Yes.
So, Lordship,
To eat into the limited department.
so Lordship, what we are saying is that the intention is that we don't give importance to the grade or the entry level. What we give is the qualification. So when this petitioner or other primary teacher, when they have the qualification, same qualifications, they are in the same zone, in the same footing, so that they can compete for the limited
That is what I
LDE,
am
Your
asking.
Lordship.
Come to again page 42.
Page 42.
Page 4.
You could have done it limited examination for area education officer from the channel of primary program. Why
But-
you have it into the?
The Lordship, let the this is
What-
the
what
case
is
of
what?
the petitioner. Let the petitioner say that any of this violates the Article 14. Nowhere he has pleaded the incompetency of the lawmaking authority, nor he has.
Here is not a question of
yes.
competency. Here is a question of treating unequals equally or
So where
treating.
is his pleadings? He has to point out, and he is stating that Your Lordship, he has challenged the service rule. He has not annexed the service rule.
Those are now technical.
Though there
You
is,
have, you could have raised the preliminary point on.
I have raised it in my affidavit in opposition also, Lordship.
No, at the time of making it, the issuance of notice. It is too late in the day now. Do you have any concept of what is limited departmental examination? Any idea? Because I had the idea, which may be wrong. Only issue is that broadening the scope of.
Lordship,
And there, my lord will see, under Rule 15, no education qualification is prescribed. Rule 15, if lordship.
education.
Rule 15 is Rule 15, no, education,
prescribed.
education and qualification is concerned.
Yes,
I think
that's
that it is
prescribed.
there.
My lord, no. Rule 15,
From
it doesn't
amongst
mention.
the graduate teachers, primary.
All
teachers,
primary teachers, that's all.
And those
Their
holding
edu-
equivalent
Their
posts.
education qualification is there already in the
No, my
rules.
lord, that part I want to point out,
And
my
those
lord.
holding equivalent post with 50% marks relaxable by so and so.
Scheduled prep,
different
scheduled
with
class is different issue, my lord.
so and so. He must have served at least 10 years of continuous regular service as their postgraduate teacher. Why postgraduate? PGT has come now.
Lordship, even postgraduate teacher also, they can, because as per the service rule, even the graduate teacher also, they can be recruited as a graduate teacher. That is in para page 12, Your Lordship. Recruitment by selection from lower grades.
Page
Because we
12,
have the
page
page 12, rule 12. Before that, Your Lordship, I will take you to page 3, rule 3, the method of recruitment. We have 4 types of recruitment. Method of recruitment, page 3 of the service rule. The method of recruitment to post specified in the shall be as follows: by direct recruitment, by recruitment from lower grades, and by promotion or by selection through limited departmental examination. So as per rule 12, even the postgraduate graduate teacher, even if they have the postgraduate degree, they can be recruited from the lower grade as a postgraduate teacher, Your Lordship, because 30% of the seat is reserved for them. So the intention is for accelerated promotion to select the best so that they do not wait in line for the turn, which may otherwise not reach during the service period.
No, idea is quite all right.
Yes.
I'm not saying about the idea. How postgraduate teacher can become graduate teacher? You said that.
Postgraduate, okay. Lordship, page 12 para rule 12. Recruitment by selection from lower grade. The following posts shall be filled up by recruitment by selection from lower grades through departmental selection board on the basis of merit cum seniority. 30% of the vacant posts of postgraduate teachers occurring in a year shall be filled up through a selection process by recruitment from amongst graduate teachers and primary teachers having postgraduate degree with 50% relaxable by 5% for scheduled tribe, scheduled caste, differently able candidates at the master degree level with B.Ed, B.A., B.Ed, B.Sc, B.Ed, and has rendered a continuous service of 7 years as a graduate teacher and primary teacher.
My lord, this is the
Lordship.
difference. Under rule
No,
15,
this is by recruitment.
yes.
This is basically direct recruitment.
No, Your Lordship, from the lower grade. This is a recruitment by selection from lower grade, only those who are in service.
What is the concept between recruitment and promotion? First, you tell me.
Yes, promotion means you get to a higher post, Your Lordship. And recruitment means you will get to a higher post through a recruitment process, Your Lordship.
It will be new appointment.
Because here, Rule 5 says, by direct recruitment, recruitment from lower grade, by promotion, selection through limited departmental examination, so Lordship.
These are direct recruitment.
No, these are not direct recruitment, Your Lordship. These are not. 30% of the vacant posts, Your Lordship. And the rest is for
Come to the recruitment.
direct recruitment is there. Number A is direct recruitment. Number B is recruitment from lower grade. Rule 5, page 3. Number A is by direct
This is
recruitment.
another mode of recruitment. First is direct recruitment.
Yes, Lordship.
This is B,
Mm.
by recruitment from lower grade.
Yes.
But still it is a recruitment.
Mm.
This is not promotion.
Lordship.
C, A, B, C, D.
Mm.
One is by direct recruitment. That is
Lordship.
from the open market.
Yes.
This is B is by recruitment, but from a limited market.
Only from the
But it is
person
still
in
recruitment.
service. Yes, Lordship.
Because there is a, I think, to my knowledge, there is a difference between recruitment and appointment. Recruitment and appointment. There is a difference. That is why the word recruitment has been used. Then C, by promotion. It should be D, I think, by selection through limited departmental examination.
Yes, Lordship.
Now, all are different. I think if 100 posts are there in a year, 30 will be conducted by the departmental selection. Amongst the
Lower grade.
lower grade. That is what the intention perhaps is. Under rule 12, 30% of the graduate teacher. So out of 100, 30 is gone. Out of 100, 30 is gone by recruitment from lower grades. Then what is a promotion? What is a promotion quota?
My lord, Schedule 2.
Schedule 2.
My lord, sure.
Feeder, what is a feeder cadre? If graduate teacher can be promoted?
My lord, page 29.
29.
Page 29, column 9. 70% direct recruitment, 30% by recruitment from lower grades. Very clear, my lord.
So this is 30% from recruitment by lower grade.
Yes.
So rest 70%.
Direct recruit.
Direct. So both are direct recruitment,
Yes.
but one is from open market.
Very much.
One is from
Lower grade.
lower.
And for that, to understand better, my lord, if lordship comes to page 30, next page. Recruitment from lower grade, lordship will understand from here very clearly. How the lower grade employees should be recruited through promotion from lower grade. So their next promotion is to the post of graduate.
There also primary teacher has been included.
Yes, the 100% primary teacher only. So their promotional channel is to become graduate first, having graduate degree.
Selection board. So there, this primary teacher was at a lower
Yes.
pedestal.
Yes.
It was the feeder cadre for graduate teachers.
Graduate, provided they have qualification.
Provided they have qualification, graduation,
Yes.
BA, then also.
70 is, like lordship has pointed, open market, 70.
Yes, open.
Then 30 is from the lower grade to be recruited.
Limited
And
market.
Limited, and that also
From
30%.
So there it is, primary teachers are clearly at a lower.
Lower grade. Yes.
So
Now
there-
question is by making them equal to participate in the limited departmental examination.
Yes.
for higher post,
Or still higher.
two stages.
We understand. Limited departmental examination is for on the basis of merit to the next post.
Yes.
But here it is it is jump for
Two stages.
2 stages.
Graduates-
Primary teacher
Graduate,
without serving as a graduate teacher.
then senior graduate.
That's why, Lordship, I have been repeatedly saying that we don't give importance to their grade or to the entry level. We are only concerned with their qualification, educational qualification. So, Your
The
Lordship, for
concept
that.
is, Supari, please, it is not recruitment. Please come to, let us understand, we are also learning.
Yes, yes.
Lordship,
Come to rule 5 again.
Rule 5A.
Rule 5 again.
It talks about,
Rule 5 again.
yes, by direct
We have
recruitment.
understood what is direct recruitment.
Yes.
We have understood B by recruitment from lower grades.
Yes. Lordship.
We have understood normal channel of promotion, C by promotion. We want to understand by selection through limited departmental examination. That is what we try to.
So,
We are
Lordship,
trying.
Lordship, I may be allowed to read my affidavit, page 6, paragraph 10.
You want to promote merits. That is what.
So, Lordship, I may be
But while
allowed to
promoting
read.
merits, whether that we understand, because this D by selection through limited departmental examination, it is an accelerated promotion.
Yes, yes.
That is what we understand.
So, Lordship,
If you-
let me
please,
read.
please, please,
Let me
please.
read my affidavit.
You'll read. You'll read.
Page 10.
You'll read first.
That with regard to the
Let
statement.
me put forward my view. Then you read. We understand that normally limited departmental examination is for an accelerated kind of promotion.
Lordship.
So normally we understand that it is from the feeder category, right? So basically C, A and B are rule 5, A and B are recruitment, and C and D are basically promotion. Promotion.
Yes.
D is accelerated promotion. Okay, I have understood so far, subject to demolition of that idea by you. So then also, the person who are in the feeder category participate in the process for an accelerated promotion. Meritocracy. Meritocracy. Not typical bureaucracy. Right? In IS also, other persons from other services are eligible to be inducted. So here, under the normal channel of promotion, a primary teacher having graduate qualification and other qualification of graduate teacher is promoted to
Graduate teacher first. That is the first stage.
Then thereafter,
Senior
he
graduate.
goes to become senior graduate
Yes.
teacher or whatever
Yes.
is there.
Only
Now
then.
here is a question. It's like that. They will jump 1, but primary teacher will jump 2 by way of limited departmental examination. This is not normal promotion. And not normal promotion by departmental examination also. It appears to be that those two who are at a different pedestal, they have been made equal to participate to go to a higher position. It would amount to double promotion for primary teacher and single promotion for graduate teacher.
That is the difference.
That is the basic issue. I
Basic
have
issue.
understood.
Yes,
That
yes.
is basic.
Now it will be tested against Article 14, 16.
Yes.
That
Lordship.
is the
Yes. Yes.
you have the competence. But
Yes.
competence does not make that to
Exactly.
make arbitrary law.
Lordship.
So that is what that equals.
Oh.
Whether this differential, what is that?
Limited.
Differential treatment,
Okay.
reasonable classification, all these concepts, this issue is to be tested on those parameters.
Exactly. Exactly.
I am not
That was my other thing.
service better for 5 years,
Yes.
but this is my idea.
Yeah.
Yes, Madam,
Yes.
this departmental examination, limited departmental examination is a little bit confusing.
Lordship, so.
Here actually like by introducing this provision, you are trying to give double promotion to
Yes.
the primary teachers, whereas a single promotion to the
Graduate.
graduate teachers. So that is what is the serving of mind.
Yes.
Injustice,
So,
injustice system.
what my reply is that, Your Lordship, it will be true competitive examination only. So there is no question of discrimination to them, Your
In the
Lordship.
open market, then
So primary
brilliant engineer might come
teacher is
with
the
MBA
lowest.
degree.
Yes.
Primary teacher is the lowest grade in the school, Your
Brilliant
Lordship.
engineer with MBA degree will come because Unemployment is everywhere.
So, Lordship, the criteria here is that they should have the B.Ed, PSTE, DLED, Your Lordship.
No, that is
So-
okay. Regarding qualification, it is okay. Only the jump,
That is what is what.
only the abnormal jump for primary teachers.
So, Lordship, I have been repeatedly saying that we are not giving importance to the grade. That is, grade is the graduate teacher or the primary teacher. What we are seeing, yes.
We understand it. Please break that idea.
Mm.
That limited departmental examination is associated with promotion.
Mm.
Normally, we understand.
Mm.
Normally, we understand. Limited departmental examination is usually associated with promotion of accelerated nature.
Mm.
It is not normally associated with promotion of accelerated nature by way of double promotion.
Lordship,
That is what.
okay, Lordship, I may be allowed to read my affidavit,
May
Lordship.
proceed.
Para 10, page 6, Your Lordship.
Nothing more than that, perhaps.
Para 10. That with regard to the statement made in paragraph 8 and 9 of the writ petition, the deponent states that the crux of the contention of the petitioner in assailing the virus of Rule 15, being that by allowing the primary teachers to compete in the 20% reservation for LDE, the cadre of graduate teacher has been wrongly equated with that of primary teacher in matters of promotion. Such contention is wholly misplaced and misconceived for completely missing the intention of the rule-making authority. While introducing the provision of Rule 15 read with Schedule 2, Clause 2.7, Schedule 2.2.7 of the service rules specified the manner in which the post of assistant headmaster, junior education officer is to be filled up. 80% of the vacant posts are to be filled by promotion from amongst the confirmed senior graduate teachers, senior legal assistant, and 20% of the vacant posts are to be filled up through LDE from amongst the graduate teacher, primary teacher, and others holding equivalent posts. Rule 15.1 pertaining to LDE is reproduced here in below for quick appreciation. I'll skip this one, Your Lordship. Therefore, the eligibility criteria for satisfying the criteria prescribed by Rule 15.1 for LDE are the graduate teachers, primary teachers, or other holding posts should possess number A, degree, postgraduate degree, B, B.Ed, PSTE, DLED, and number C, 10 years of continuous regular service. The other relevant rules which indicates the intention of introducing the LDE provision in the service rule is Rule 15, Clause 3. Rule 15.3 specifies the subject for competitive examination, which inter alia includes papers on general knowledge, general English, professional education, fundamental rules, service rules, and office procedures. Therefore, the provision of LDE has nothing to do with equating the post of graduate teachers with that of primary teachers. By introducing the provision of LDE for 20% of the post of GEO-AHM, the petitioners are also provided with the opportunity to compete with others and attain accelerated promotion by selection to the post of GEO-AHM.
We understand accelerated
Yes.
promotion, but
In the
accelerated
absence
double
of
promotion.
yes, in the absence of LDE, the petitioner would essentially have to wait for the turn to be promoted to GEO-AHM or retire without reaching it. Then para 12. That the statement made in paragraph 11 of the writ petition are denied. The deponent states that there is no question of irrationality clubbing the graduate and primary teachers. The said contention is completely misconceived. It is further stated that Rule 15 is not confined to only graduate and primary teachers, but also to any members of the service holding other equivalent posts to that of graduate teachers, primary teachers, or any other categories of teachers, provided they fulfill the eligibility criteria. The LDE provision under Rule 15 of the service rules has to be introduced to achieve added efficiency in administering education services by improving the caliber in the cadre of GEO-AHM.
Now this next paragraph, please
Yes.
read slowly, please
Yes.
read slowly.
The accelerated promotion by selection envisaged by Rule 15 is not the normal route of promotion specified under Rule 13 of the service rule, wherein the principle followed for promotion is merit cum seniority for the fitted post to the immediate next higher post.
What does it indicate?
So here,
What is that accelerated promotion by selection envisaged by Rule 15?
yes, Rule 13
Rule
is
not the normal route of promotion.
Yes,
specified by Rule 13.
Yes.
Let us see Rule 13.
page 12, Lordship. Page 12. All recruitment through promotion from a lower grade to a higher grade of the service under Rule 61C for gazetted posts shall be done through departmental promotion committee consisting of the following members. Yes. So all these are the manner in which the promotion has to be made
What is the criteria there?
for promotion. The criteria are, Lordship, a statement showing the number of vacancies to be filled up by promotion during the recruitment year. B, a list of eligible official to be considered for promotion placement, along with the
Very
letter seniority. Yes.
Hmm.
So, Your Lordship,
When the principle followed, his merit comes to an immediate next higher post.
yes, so Rule 15 is merit cum seniority from the feeder post, but for Rule 15 is the accelerated promotion, Lordship. So it should not be taken only from the feeder post. Any person who qualify the eligibility criteria.
Anywhere, whether anywhere it is defined, what is the purpose and object of limited departmental examination?
Lordship, number 2, the next para. The intention of the rulemaking authority in reserving 20% of the post of JEO, AHM to graduate teacher, primary teacher, and others holding is to get the best available in the pool, where a specific set of educational qualification has been prescribed without giving due importance to the grade or entry-level qualification. Therefore, any member of the service, from graduate teacher, primary teachers, and other holding equivalent posts, fulfilling the prescribed criteria under Rule 15.1 can compete in the LDE. Rule 15 do not seek to equate the eligibility of both the graduate teacher and primary teacher. It is stated the whole premise of the petitioner is completely misconceived for missing the intention of introducing Rule 15. Rule 15 is for the basis is only on the eligibility criteria, which has been prescribed. So, Lordship here, if they fulfills the other two criteria also, if they do not serve 10 years of continuous service, they cannot participate in the LDE. So they have to fulfill the criteria which has been laid down under Rule 15, Your Lordship.
It will come back.
Lordship.
Next, give it back. Admit talaga sa yes, application. He said, okay, I'm not sure, I'm going to the commission. I don't know, just. On the girls. First, first, after the tom na hobo, to adi jo. After. I said, no problem. In my case, I was. I mean, I don't know the words. So, paragraph, submission,
I have only one supplementation. With the big, yes. That's right. Conviction to आप है जेल दे दे any type
Otherwise, there is after you serve for human being that there will be a war for you to be released. Huh? I don't know what tomorrow can
Oh, anyway, well, I'm pitching to, I think you are widow, then I'll come with you. Yes, yes. You are not depriving me, but. More charge of not to go. It's not like. When you're how and there is a judgment. Well, you know, Captain, you know. There is to. How?
Yes, anything, any authority?
My lord, yes. I have one judgment. This is the challenge was made against the Himachal Pradesh High Court rules. Similar to this. My lord, this is 1994, volume 2. The judgment is short, so I may be allowed to read out the whole judgment, my lord. It is, no? Page 11, page 412. May I read it, my lord?
Yes.
Paragraph 2. This is short, so I'll just read. Facts are similar, my lord. In the establishment of the respondent High Court, there are two sets of equivalent hierarchical posts, with clerks, translators, and revisors on one hand, and clerks, senior assistant, and deputy superintendent on the other. Above the post of revisors and deputy superintendents is the post of superintendent, which is common promotional post to both the sets. Paragraph 3. The appellant was appointed as a clerk on July 2024, 1972, and was promoted to translator on July 30, 1979. The pay scale of the translator at the relevant time was rupees so and so. It was revised to rupees so and so with effect from January 1, 1986. Thereafter, she was promoted to the post of revisor on February 26, 1992, which carried the pay scale of rupees so and so. Paragraph 4. As against this, respondent number 2 was appointed as a clerk on January 7, 1974. He was promoted to the post of senior assistant on August 14, 1986. The post of senior assistant earlier carried the pay scale of rupees so and so, and with effect from January 1, 1986, the pay scale was revised to 3,200. Paragraph 5. It is thus apparent that the post of translator and the post of senior assistant were on a par. There is also no dispute that the post of revisor is on a par with the post of deputy superintendent, which carry the same pay scale as that of the revisor, wage so and so. 6. Both as clerk and as translator, which is the post equivalent to that of senior assistant, close bracket, the appellant was senior to respondent 2. Further, although the appellant was promoted to the post of revisor, which post is equivalent to the post of deputy superintendent, respondent 2 was not promoted to the post of deputy superintendent in that line of promotion. There is no dispute that there was a combined seniority list maintained and the appellant stood at serial number 13, whereas respondent number 2 at serial number 17. It is also not in dispute that the post of superintendent is the next promotional post available both to revisor and deputy superintendent. 7. On December 3, 1992, overlooking the claim of the appellant, respondent 2 was promoted to superintendent, which post carries the pay scale of rupees so and so. The High Court relied upon the High Court of Himachal Pradesh Recruitment Condition of Service Rules 1992. The 1992 rules for effecting the said promotion. Rule 10 of the rule of 1992 rules, which provides for the appointment to the post of superintendent, reads as follows. Quote, by promotion from amongst graduate deputy superintendent or revisors with minimum 3 years of service as such in the ratio of 4.1, failing which the promotion from amongst senior assistant / translator with minimum 6 years service as such in the same ratio. Explanation. After promoting 4 deputy superintendent or senior assistant to superintendent from general category, 1 revisor oblique translator shall be promoted as superintendent from amongst revisors or translators category. Paragraph 8. The substance of the rule is that the appointment to the post of superintendent is to be made by promotion from amongst the graduate deputy superintendent and revisor with a minimum of 3 years of service in the ratio of 4.1, that is 4 from deputy superintendent and 1 from revisor. The appointment from revisor to the post of superintendent is to be made only after 4 from deputy superintendents are promoted to the said post. If none from the deputy superintendent and revisor with a minimum of 3 years service is available, the appointment is to be made from amongst the senior assistant and translator with minimum service of 6 years in the said post. 9. The result of the rule was that since the appellant had not put in 3 years service as revisor, she was disentitled to the post of superintendent. The position further was that on the relevant date, that is December 3, 1992, there was no deputy superintendent or revisor with minimum 3 years service in the respective post. Hence, the post was given to respondent number 2, as he was senior assistant with more than 6 years service. Consequence of the rule was that had she continued as translator, being senior to respondent number 2, she would have got the post of superintendent. She lost the same because she was promoted to the post of revisor only a few days earlier to the appointment of respondent number 2 to the post of superintendent, which in effect was a double promotion to him. Since 2 events, namely her promotion to the post of revisor and that of respondent number 2 to the post of superintendent were close in proximity, a legitimate contention was advanced on her behalf that she was kicked up to the post of revisor only to felicitate the promotion of respondent to the post of the superintendent and thus to deny her to the said post. 10. The appellant therefore approached the High Court by way of a writ petition challenging the validity of the said Rule 10 and for quashing the promotion of respondent number 2 and also for her promotion in his place. The division bench of the High Court held that Rule 10 of the 1992 rules was valid and dismissed the petition. It is aggrieved by the said decision that the present appeal has been preferred. 11. What is pointed out to us on behalf of respondent High Court is that the said Rule 10 had become necessary because there were more deputy superintendents than revisors, and the senior assistants and translator were stagnant for want of a promotional post. Hence, the said rule was framed by a committee of judges to provide suitable avenue of promotion to both deputy superintendent and revisor on the one hand, and senior assistant and translator on the other. It was also pointed out that even the earlier Rule 11 of the 1990 rules was almost on the same pattern. In fact, by the said earlier rule, all graduate court employees who had put in minimum of 6 years service in the grade of not less than rupees so-and-so were eligible on merit for promotion to the post of superintendent. Under the 1990 rules, therefore, all senior assistants and translator as well as deputy superintendent and revisor were eligible for being considered on merit for promotion to the post of superintendent. The only 2 differences which the Rule 1992 rules brought about in the earlier situation were that they provided firstly that the deputy superintendent and revisor who carried the pay scale of more than rupees so-and-so with a minimum of 3 years service were eligible to the post of superintendent, and it is only failing the availability of the eligible candidate from the said 2 categories that the senior assistant and translator should be considered for the said post. Secondly, a proportion proportion between deputy superintendent and revisor was laid down for promotion to the post of superintendent, paragraph 12. In this case, it is not necessary for us to go into the question whether Rule 11 of 90 rules which provided for the promotion to the post of superintendent was valid or not. Even assuming that the validity of 1990 rules was not challenged, that fact by itself would not validate the present rule then if it suffer from an inherent infirmity. The basic weakness in the present rule 10 is that it places two unequal sets of posts on a par with each other, and also prescribes qualifying service for the higher post as well. The posts of the deputy superintendent and revisor admittedly are posts higher than those of senior assistant and translator respectively. If the incumbent of both the sets of posts are to be made eligible for promotion to the post of superintendent, no qualifying period of service can be prescribed for the incumbent of the post of deputy superintendent and revisors. If senior assistant and translator are to be provided with promotional avenue, more posts of deputy superintendent and revisor, which are above the post of senior assistant and translator respectively, should be created, my lord. And first, the senior assistant and translator have to be promoted to the said post. In fact, the appellant who was a translator was first promoted to the post of revisor. We are informed that no eligible deputy superintendent and hence respondent to who was holding the post of senior assistant post below that of the deputy superintendent had to be promoted to the said post as he had put in 6 years service as required by the said rules 10. Rule 10 of the 1992 rules is thus iniquitous and indefensibly unjust. It violates Article 14 of the Constitution since it treats unequal as equals, and what is more, gives unwarranted advantage to the incumbents of the lower post over the incumbent of the higher post. 13. We therefore strike down the Rule 10 of 1992 rules and direct the High Court to frame an equitable rule for promotion to the post of superintendent in place of the said rules. 14. We have no doubt, my lord, that much, my lord, yes. So therefore,
Anything on limited departmental examination?
my lord, that I don't have for the time being, I'm sorry. I'm very sorry about that.
Because what is the purport and
Correct,
object
my
of
lord, that I
that?
have
You
understood.
have to
what was-
understand, because I have not come across any
Yes,
limited
yes.
concept, but
My
this
lord.
is my idea, but
Yes.
this has to be.
But
There
more or
is
less,
so many literature, so many things are available on department.
Yes.
This is my idea, but that may not be correct, subject to correction.
I have understood lordship's interest in that, yes.
That what is limited
Yes,
department
I got it.
examination, whether for purpose of appearing,
Yes,
the zone of consideration can be expanded
yes,
beyond the feeder. That is the only question.
yes.
Yes, so what
Now-
the stake is contending is that we do not look on the grade, we only consider the eligibility
But
criteria.
currently, by making this zone of consideration, you have treated persons from two grades as equal.
Only on the basis of qualification.
Maybe I have understood.
Mm.
Now I have to because you have not supported anything on this limited departmental examination concept. My idea, subject to correction, I am repeatedly saying
Yes, ma'am.
that it is just an accelerated promotion. In the guise of accelerated promotion, it cannot be double promotion.
You know,
That is what I am repeatedly saying. This is my idea, but this is subject to correction.
Mm,
I am quite open to learn.
mm.
My brother, subject to my brother's idea. So this is what is the concept of limited department?
yes.
See, it is basically an alternative to stagnancy by they encourage meritocracy, merit. Though in a normal similar promotion, it is merit cum seniority, but stagnancy is always there. You carve out 20%, and out of the zone of consideration,
Yes.
you promote whoever is the most
Yes.
meritorious. But while weeks, it appears that it is not the normal feeder cadre, but all many others have been included, not only primary teacher, primary Hindi teacher, primary
Yes,
physical
anybody,
teacher,
yes.
everybody.
Yes, having the qualification. Yes.
So it has expanded about 10 times. Maybe Hindi teachers are less, maybe physical education teachers are less, but still it has gone at least 2 or 3 times. Whether that is the concept of limited departmental exam.
My lord, if I'm permitted.
Otherwise, zone of consideration, primacy, unequals are made equal.
No, lordship, no.
Well,
They are
if-
on equal, your lordship, because we look only on the criteria, eligibility criteria only. So when they possess the eligibility criteria, they are on the equal.
Otherwise,
footing.
this primary teacher are at very lower grade.
Though, that's why your lordship,
Lower grades.
yes, it is under the lower grade. So the intention of the,
Service is there.
so lordship, then I may be
Show me
allowed to.
anything.
And there is no authority because lordship, I may be allowed to read my this paragraph 9 of my affidavit again, your lordship. I have not read page 5, paragraph 9, your lordship.
Support your submission.
Madam, we accept your submission. We accept your submission, and we also accept the fact that actually this limited departmental examination is on the basis of meritocracy. Yes, you are making a submission. That we accept. But what is disturbing us is this limited departmental examination is to be from the immediate feeder.
Yes,
That is
ma'am.
what we
That is-
accept.
That is what we
that
are
is the
asking.
thing.
So I
That is
have
the
even
thing.
So
stated,
that is why my lord was saying, you actually satisfy your submission with law.
so
Then we will be, not on the basis of your affidavit. Now we have understood your case.
Doesn't make.
lordship, that's why I've said
Constitutional
that it is rule 15 is opposed to rule 13. That is the normal rules. So your lordship, in order to prescribe all the condition,
What is
whatever,
the
that is
purpose of
coming.
limited departmental examination? Please tell me that.
That is to that eligible.
Okay, then please tell me what is
Yes.
the basic purpose of limited departmental examination? It is simple accelerated promotion or simple double, triple.
It's not a
What
double.
type?
It's not a
Please ask-
double.
Please tell me.
Yes, it's not a double, your lordship. Lordship, what the intention is that the eligible, the qualified, and the deserving candidates who are having the requisite qualifications, they should not remain stagnant in the post so that they can be promoted through a competition, your lordship.
Madam, we accept your submission, but we also want you to support your submission with law rules. Not just on the basis of just verbal.
Otherwise, your lordship, without prejudice, your lordship, but lordship, if we go through the rule 15, on the face of the record also, it's very clear, your lordship.
You are submitting on the basis of the rules, but my lord wants to know what is the purpose and intent of limited departmental examination and support that.
Am I clear or not?
Lordship,
I am.
My lord, we got a word. I got a.
Lordship, I leave to your lordship. But your lordship.
Don't leave it to us. Leave it to us.
I'm asking you query, and you are here as an additional advocate general to assist. That what is the both of? I am not putting it to you. I am putting it to Mr. Joe.
My lord, my lord.
That what is the basic concept, fundamental idea behind limited departmental examination? What is it? Is simply an accelerated promotion from the
Lower.
feeder cadre, or it may mean more. That is what I've been asking. I have understood your idea.
So beyond that, how can I explain, your lordship? I have even stated here also, we say that
That should
No,
be
we
your
have,
submission. You are making submission on facts. On the basis of your affidavit, you have not actually satisfied with law. What is
okay,
law?
Lordship.
So we want more. That is why we want to extract more from you. It is not that we are going against you, but we want to extract
We have to
more.
know that whether this is permissible, then they have no case. If it is not permissible, then they have a case. That is what
Lordship,
we're trying to
Lordship.
find out. I'm not neither supporting his case nor opposing your case. I am trying to find out, I'm trying to get out of you what is the fundamental idea behind limited departmental examination. And you are more accustomed to service laws than me. So that is what the query of the court is. We are not deciding it. We are trying to find out the basic fundamental concept behind limited department examination. Otherwise, this can be home to the open market
That is,
also.
Lordship was
But I
saying,
have said that brilliant engineer with in this unemployment scenario, brilliant engineer with PhD, MBA, all this qualification may come in, and they better will administer school education.
Lordship, only on
Question
that,
is-
yes.
Yes, please tell.
Only on that. As Lordship happened, if the examination is open to all fresh candidates, then we'll have no case. But the issue is the members are drawn from the within service members. There we have been deprived. If the source is drawn from open market, then we'll have no case. That's what I'm admitting. But since the source are drawn from primary teachers and graduate teachers who are not
Okay.
equal.
Okay, now what is the concept? We are asking the basic fundamental concept, limited departmental examination. Because it is found in many service rules. What are there? What is there? In central service rules, in many state service rules, limited departmental examination, the concept is there. What is the prevalent zone of consideration there? Here we have found expanded zone of consideration. So the idea is whether
My lord.
by incorporating Rule 15, whether unequals are made.
Yes.
That is what the concept. If not, you have no case. So what is the concept? That is what I ask.
Yes.
Both of you.
Yes.
I am also trying to find out, I'm not getting it.
Both of you, you have come strongly prepared in support of your respective cases, but I think
That part.
something is missing with regard to limited departmental examination. As my lord have said, in many service rules, this concept is there. But actually, limited departmental promotion is limited to the immediate feeder grade.
Yes.
Now the zone of consideration for promotion for this examination, limited departmental examination is expanded. So that is what is actually like disturbing and puzzling.
Correct, my lord.
So we want to extract
I
more from
agree.
you.
I agree. That is true.
That is what we are trying. One. Limited department.
My lord, then I have one submission. Give us a short time, we'll do research and then we'll just supply that judgment on that point, We have understood the difficulties of this. Right now, immediately, I don't have immediate answer now.
Because it is a challenge to the
Correct.
rules.
I understand. I
It's
understand.
not interstate.
I agree. I agree.
Interstate.
I agree.
It has vast
So
ramifications.
concept of limited departmental exams. On that concept, both of us will try our best.
Find out, it looks like central government has service rules for limited departmental examination from the feeder. It looks like central government. I'm not saying that that
Yeah,
is
madam.
the only permissible thing. This may be also permissible, but to equate the zone of consideration between two, whether it is permissible for the purpose of limited departmental examination. The answer should be, what is the purpose of the limited departmental examination? That other than normal promotion,
Yes.
it is an alternative way of promotion from the feeder cadre, or it can include
Madam, that is the point.
other cadres.
Yes.
That's all.
That is the area only.
That is the area. If it is in your favor, then rule is bad.
Yes.
If it can be expanded, then rule is good. But what is the basic
Yes.
fundamental concept behind limited departmental examination?
My lord, in that case,
Find
the
out.
judgment may be reserved and we'll come and try
No,
our
no,
best
that-
to
no,
assist.
no. Then if you don't come, we have to make the research.
My lord, a small,
That is the easiest way.
a small thing that I want to
can
point it
do it.
out, small thing. Well. That's one. Kenapa dia bola?
Next,
Otherwise, at 2, we can research now and bring the judgment. Yeah, no, at 2.
research.
Mm,
I made a research. I could not.
mm.
So
Yes,
you may
your
be successful.
controversy is only confined to Schedule 2, Clause 7. Limited departmental examinations, that's it.
But basically the concept.
Otherwise, factually, department have admitted that there's flaw, it's bad. So they have set up a review committee already to review the entire service. There's a committee.
No, we are only concerned with Rule 15.
Now, government has realized that this is bad. So I have annexed the document. They have set up a review committee consists of.
That should come out from the mouth of the learned actually. The rule is bad.
They have document, I have annexed the document. Annexure 4.
Okay.
Next item.
They can come up with something. Should. Please call again. We are not passing in order. Call again.
Just see causeless.
Did inside.
Yes, no. Let's take this one.
For orders. Yes. For orders, item number 45 and 46.
What is this I?
Lordship, that is for condonation of delay.
Delay.
Yes, but Lordship,
143 days.
143 days.
Lordship, on the last occasion, as regard the service upon respondent number 2, I've been directed to ascertain whether,
Service is complete.
Lordship,
Complete.
yes,
143 days delay. And offenses?
POCSO.
4, POCSO Act. Yes, state has any objection?
Lordship, as far as delay is concerned, I will leave it to the wisdom of my lords.
Heard Mr.
Theo.
Theo, Learned Counsel for the applicant. Appellant, and Mr. KB Angami, Learned Public Prosecutor for the respondent number 1.
One, Lordship.
State of Assam or State of Nagaland. Full stop. On the previous date of listing, comma, that is on 11/9/2024. This court requested the learned public prosecutor to obtain a report from the officer in charge, fake Omen police station, as to whether the notice up in the respondent number 2, informant or
The victim.
victim, respondent number 2, that's victim, has been duly served sufficient notice upon the respondent number 2, that's informant. I mean, Mr. Angami Learned Public Prosecutor by on the basis of a report dated 18/9/2024 received by him from the officer in charge, Women Police Station, fake, comma, has submitted that the notice has been duly served upon the respondent number 2. A photocopy of the said report is also placed by Mr. Angami before this court. Para. The instant application under Section 5 of the Limitation Act 1963 is preferred, seeking continuation of delay of 140 days in preparing the accompanying appeal, criminal appeal against the judgment and order dated 9/12/2024, passed by the Court of Learned Special Judge Fake Nagaland in sessions within bracket special bracket rules, case number 05 of 2023, comma, which arose out of GR case number 46 of 2023 and fake Omen police station case number 01 of 2023 by the judgment and order dated 9/2/2024, comma, the Learned Special Court convicted the appellant hearing who stood the trial as the accused, comma, for the offense under Section 4 within bracket 2 of the Protection of Children from the Sexual Offences Act. 71 years old.
71 years.
And he has been sentenced
To 20 years.
to undergo imprisonment for 20 years and to pay a fine of rupees 1,000 with default stipulation. Full stop. We have gone through the statements and amendments made in the instant interlocutory application, wherein the applicant has sought to explain the period of delay of 143 days. There is nothing in the application. KP Angami fairly submitted, and this thing, POXO will have participatory right at the stage of appeal. Despite service of notice upon the opposite party number 2 as informant, there is no representation on behalf of the respondent number, opposite party number 2, as informant till date. Participatory right in the accompanying criminal appeal. Condoned. It will come again. This has been registered or what? Appeal? Appeal is registered.
Yes.
Let us see it. Appeal. What is this bail? Bail application?
Yeah, bail application.
389. Suspension of sentence.
Suspension of sentence as well as bail.
Appeal has been registered or what?
Yes, ma'am.
Appeal is registered. But what is the practice here? We generally do not register the appeal until the delay is confirmed. List the in view of the order passed in the appeal. List the accompanying appeal for admission on Thursday. To follow the practice. We do not register. Unless the delay is not condoned.
Yes.
The appeal is not born. That is the legal counsel. We put it on Thursday. Next Thursday. Appeal. Delay is condoned. I is allowed.
For hearing, item numbers 47 to 49.
May it please, Lordship. My lord, I'm the counsel for the petitioner here. Here 47, 40, 49, we are challenging the rules, police manual,
Rule again.
police manual. So may I pray that for the earlier case, we want to go and do some research. So if this can be passed over to Monday.
Monday, I do not know. Monday, Honorable Chief Justice is coming.
Lordship,
Otherwise, we are told that
Monday and Tuesday, Honorable Chief Justice will be here.
Lordship can fix it on Thursday.
We don't know about
Yes,
at least Monday and
on
okay,
Thursday.
Thursday, then my lord, Thursday, no problem.
So the violation of the rule is challenge, your Lordship.
I think Monday and Tuesday will be having division benches.
Okay, no problem.
Full scale.
No problem.
So let it be after
Yes,
that.
no problem.
Lordship on Thursday.
Well, let it be after that. There will be no opportunity of single bench
Lordship.
Okay.
for those 2 days. For me, right?
Lordship.
I've been told that I have to see.
Yes.
I don't know, I have not seen, but it is prepared. So those 2 full days will be in division bench. So
My lord.
there will be no scope for single bench.
Lordship.
So difficult. It will be difficult on Thursday.
No problem.
Someday else. That is. We'll continue with that.
Well, yes, the earlier one, I'll come back
After
at
2
2.
weeks, but now.
We can put up the date also.
As per.
Oh, it will be, but it will have short vacation.
One week.
16th of October.
Lordship.
Wednesday.
My lords, 14 to 19, I'm in Tuinsang for one case.
Then
I-
23rd,
I-
23rd,
Your Lordship, I've been accommodating.
Yeah,
here.
my lord, that I agree.
So let it be as per his convenience, but no further action. Let it be as per his
is
convenience.
there any stay?
Lordship, no,
Nothing.
no stay, your Lordship.
On the prayer of Mr. A. Joe, Land Council for the petitioners.
Yeah.
And as agreed to by Mr. T.B. Jamil,
Lordship.
Land Council for the respondents. List the cases on Wednesday. Division bench will be, if 16 is not possible, 23rd.
My lord, no problem.
23rd. Okay.
Yes.
23rd. It is between you,
Lord of life.
the understanding that you will do the case.
Yes,
Of life.
my lord. Chalo, jump right away.
Huh? Hả? Chưa có. What? Limited departmental exam लगा issue material आने हुई है.
Where is Mr. Joe? He's researching. What else researching?
Oh.
So logic was asking the question whether the grammar is determined. So we come over the course of the teacher and we can participate in the.
And that is what we have also found. Let us see. Which part?
It's a point of departure. The appellant who was working as a constable with the border security force applied for the post of sub inspector general duty through limited departmental individual examination, 2018-19. What was declared immediately and the sick order was not disturbed even in the review of examination of one of the people. Agreed by the above action of the respondent BSF, appearing to the three unlawful proposals. Sub-Inspector GT, through LPCE, the appellant preferred the petition before the legal high court to question the medical result dated 27/2020 for the review examination and for a direction to the respondent BSF 2024. The writ petition submitted so far by the appellant was dismissed by the High Court by review for the day 24/9/2020. In the above actual scenario, the appellant was preferred this appeal. The motion come to a precedent. The appellant was appointed as constable GD with the BSF for 2012. After the appellant had put in about 8 years of service as a constable, an advertisement was issued by the respondent BSF inviting application for service, serving BSF male female constable, head constable, ASI, etc. for selection in the post of sub-inspector GD through LDC 2018-19. The advertisement provided for the eligibility condition of the scheme of examination. I don't need to read the other particular exam that the lordship may come to the observation of the court. Paragraph B. No doubt, employer with a higher force of the contemporary working on lower force is in the form of the acceleration of directive promotion, but it cannot be equated with normal mode of promotion. This is evident from the advertisement itself, which is unequivocal terms, states that the applicants are invited for selection to the post of sub-inspector GD in BSF through LDCE. The very fact that the applications were invited for selection to the post of sub-inspector GD notes that it was not a normal promotion, rather selection to the higher post from amongst the eligible candidates working on the lower post. Thus, the submission that the normal rules of promotion for medical examination could have been applied is not acceptable. This part selection was to be conducted in terms of the advertisement. The scheme of the selection contained in the advertisement categorically provided clearing of the examination in all the 5 stages, which included declared medical examination. This was independent and in addition of the eligibility condition that a candidate must possess the medical category shift 1 while working on the lower post. Additionally, a distinction has to be drawn between a normal promotion and promotion by selection through LTCE. Promotion by selection through LTCE vis-a-vis competitive examination is a facility or a chance given for all promotion without waiting for a normal course of promotion. It is in fact a selection through competitive examination within the category of candidates and cannot be equated with normal promotion. This being the position, the argument that a regular promotion criteria that will be applied without the negative influence, even in the matter of selection through LDC is not acceptable. And the agree was dismissed. So your lordship, the LDCE promotion through LDCE cannot be equated with the normal course of promotion.
Right, that is okay.
Means that a person can jump 2 poles or 3 poles.
That is not there, but that one thing is there. The other rule was not challenged. Rule was not challenged, but it appears that BSF rules perhaps provided for limited examination, BSF service rules, maybe. And there the category from which application can be invited is constable, GD, head constable, ASI. So it appears to be like that in your case.
Yes.
Right. But otherwise that is not under challenge. That is what we find from the judgment. Otherwise, it is like that feeder cadre are expanded. Let us see the rule.
That departmental examination is not limited to only the feeder post.
Is it there?
Yes. No, the limited departmental examination is not limited to only feeder post. Purpose, the LDCE is a competitive selection process that allows for accelerated promotion based on merit. Eligibility, the LDCE is open to people who are already in service at a lower level. The LDCE is a promotion and the European using guidelines that apply to the LDCE unions are the same as those that apply to promotion. So in worship, it is not only the leader posts that can be considered for.
Can you find out something more in support of this? Right.
If we see a constable, your worship.
No, we have seen now, we have seen. Rule is not under challenge. That is what, but this, whether you can explain this with something more, then it would be privacy in your favor. Yes, anything.
But I'm not going to entire judgment, there is a judgment. Just one, paragraph 20. Talking about the concept of limited department.
Oh, only one.
Only one.
Yes, yes, Lord.
Yes, yes.
Putting Mark's thing there. Limited department examination can be held within that. In service. Number two, it'll be only within the same category, junior, senior, but there's no lower grade. Lower grade are not included. Only among the members, there can be senior, junior, but not lower grade. And that will not change the concept of normal promotion. There's no mention that lower grade employees also included in the limited department examination. Only junior, seniors, they are together. Meaning, same grade. And that is what accelerated promotion. Where it say that it will be between among the junior, senior, but more lower grade are included. The grade are totally different, and that is in service. I'm sorry, my junior that are coming with another piece. Some little far. Oh, according to me, concept is clear. Competition will be only within the in service. Number two, among the same cadre, junior, senior, junior can be promoted on merit. That will be amount of accelerated promotion, but that will not change the net character of the normal promotion. Here in our case, it is otherwise. That will have to get all the lower grade employees.
Oh, MS Sukri has come up with one note that limited departmental examination is not limited to only feeder post, but she might come up with something more to support that.
Go through this judgment, but my submission is that Supreme Court has clearly mentioned that there is a distinction between the normal promotion and
That I know.
selection. So
We are not in dispute with that. Whether we are only on because in this case, we have gone through for Ms. Kumar during the break also. We have also gone through. But there, the category for zone of consideration were constable, head constable, all. And there the petitioner appeared, he failed medical test and so and so. The issue of that virus was not there. So court has not gone through. And observation at page paragraph 20 is that normal promotion and promotion through LDCE are different. It is an accelerated promotion, right? A junior can be, because otherwise normal promotion, merit comes seniority, seniority comes merit, whatever. Ultimately, in your rule also, it is said, though it is merit come seniority, I have seen whenever a junior candidate is recommended for promotion in a preference to a senior one, the committee shall record in writing the reasons for doing so. Right? Basically, still, though it is merit come seniority, but still reasons are to be recorded. Page 13, last 2 lines in your service rules. But if you can explain this particular thing, then if you can support this particular thing with certain document, these are somewhere, but you might find something more. Look through it. We have also very limited time. In the meantime, we will also look through. We'll just put it in part on Thursday, then we'll conclude. We'll also make research.
Mr.
So that nobody should be.
You please check what is the civil number?
That is better place on law definition, but first is. Otherwise, what my understanding, your lordship, the meaning of acceleration.
This says other thing, right? Same rank, but comparatively junior. Then for them, limited departmental examination is the scope for getting promoted ahead of seniors, because both are contrary. We want to be at least get our satisfaction. Also, your satisfaction is satisfaction. And this is a concept which is not normally used. You have not, you might have come across LDC matter, but I have not come across. So this is new to me. So let us have something more, because it may have wider consequences, right? And whether, one more thing.
No promotion doesn't affect.
No.
But the only challenge is, but as a group, no promotion.
Only advertise.
Only.
State, it is state, right? Advertisement has been state.
Yes.
Has been state. No question. Another corollary question, whether if advertisement has been published, whether there should be a requirement of necessary parties in this case. No, not required.
Because my figure that out of 3,361 graduate teachers, it is only 50 of the petition.
No, anybody can challenge. One can challenge, 50 is not. If virus is challenged on the basis of constitutional parameters. 50 can challenge. So that is their case. I think that will be their case that 3,300 graduate teachers are there. Already a vast pool of graduate teachers are there. Why you are including 10,000 more? Maybe that is their case. Already 3,300 is there. Graduate teacher in the state. And for 20%, let this competition be confined to this 3,300. Why you are expanding by including 10,000 more? That is perhaps his case. But we want to know that particular thing. Only that both are going in a different direction. This has said, in order to encourage meritorious candidates who may be comparatively junior in service, a window of opportunity is open through limited departmental examination. Right. I don't know.
Lower grade.
Lower grade.
I'm on second.
If that is the case, the meaning of accelerated promotion is.
No, accelerated promotion may not include double promotion at the same time.
If the juniors are smarter, it's just a promotion. Cannot include the lower grade.
No, suppose a person with a PhD degree joins in the post of peon and there is no avenue, he will remain as peon. Many questions will come up, but anyway, we are confined to this one. Back minute, 1 minute. No, but nowadays this is there. Interest citation. This is an interest section. I started using it. In this case, the rule is that higher judicial service in the cadre of district judge. Rule says 50% by promotion from amongst the civil judges, senior division, on the basis of principle of merit cum seniority and passing a suitability test. This is normal avenue. 2, 25% by promotion strictly on the basis of merit through limited competitive examination of civil judges, senior division, having not less than 5 years qualifying service. And C, 25% by direct recruitment. So here the rule is 50% by normal promotion, 25% by limited departmental examination from the same cadre, feeder cadre of senior judges, civil judges, senior division. Right. This is the rule. And in the other rule, the pool is different. Now we have to taste this 14. But still the root is whether Article 14. Clubbing, because of this particular rule, that we find, heaven is not going to fall within 7 days.
As my Lord is expressed, Madam Socrates, on this materials which you have downloaded from this Google, if you can actually find a very relevant judgment on this, no,
that is what.
Limited departmental examination is not limited only to the feeder post. This is the material obtained through Google.
And we are making it clear, we are always in favor of merit.
Correct.
We are always in favor of merit. Now, merit is from a big pool or a small pool.
That's all.
That's all. And on the touchstone of Article 14. and plus these rules where you are, from where it appears that primary teacher is to be promoted to the graduate teacher if he has the qualification, and plus this much years of service. Right. Then graduate teacher is also made, is by normal way to this assistant headmaster and plus. And this primary teacher has been, that normal route has been dispensed with. They are going very accelerated manner. That is what. Primary teacher to an administrator. Because primary teacher to an administrator, because they will be administrating. They are in the administration. Assistant headmaster, basically, it is an administrative post. Otherwise, headmaster does not go to the classroom. This is my normal idea. Yes, if some teachers are absent, then he goes just to control the class. He don't teach. Thursday? Yes. Only on the limited point. Heart. Thursday. Tomorrow will be very less time. In the meantime, we will also research. Research. Every Wednesday is a holiday, so you get the file earlier. Yes. You can go through. Be facilitated. Kejo for the petitioners and V. Sukri, Land Traditional Advocate General for the Nagaland for the state respondents, lays the case on so and so again as partnered. You can support this Google's material with some authentic judgment, then okay. Here, Ms. Sukriya said, produce a document from Google. Limited departmental examination is not limited to only feeder post. This is a statement, but without any supporting material. Both of you. Yes. You have this public score with you? You have a copy, okay. I have two, so I can supply. I can supply one to Mr. Joe. No, third.
So the rope is still in the middle point.
Still.
Still.